Greetings to everyone present. My name is Ankit Malhotra. I'm the co-founder and president of the Jindal Society of International Law. It is my privilege and an honor to welcome someone who's become a part of the Jindal family of the society and of the center, who's been constantly supportive of all our efforts and is continuing is this deeply and perhaps mutually beneficial relationship with the society. But before I introduce him and the topic which he will speak upon today, let me just say a few words about the Jindal Society of International Law, which was formed under the aegis of the Center for the Study of United Nations, under the expert guidance and tutelage of Professor Dr. Weston Rubowski. We were officially launched on the 18th day of November by the Herbert and Rose Rubin Professor of International Law, Professor Jose Enrique Alvarez of New York University, along with our university's respected Vice Chancellor, Professor Dr. Rajkumar, and a very dear friend of the Society and Center, Professor Dr. Mohan Kumar. The purpose of the Society is to increase the student engagement with the subject matter of international law through its various initiatives. The Society is an attempt to bridge the lacuna by streamlining resources and inculcating an overall interest in the vast expanses of international law. We aim to provide space to young international law enthusiasts to nurture their interests in this field of law and practice. The spring lecture series of 2022, entitled The Colloquium on Challenges to Global Governance and Humanities in the 21st Century, offers a compendium of scholarship from the academy and professional experience from the bar. Over the past year, the Society has hosted over 100 renowned speakers from foreign universities, the International Law Commission, international law firms, the United Nations, the Institut de Droit International, the World Bank, and the Hague Academy of International Law. Through our previous series, we endeavored to study the different contours of international law through the speakers who cover and address their respective areas of research based upon their years of practice and research. Given this vast ecosystem and the engagement of international law in it, the Society aimed to study the fragmentation and fertilization of the various disciplines in this ecosystem of public and private international law. Thus, as a result, the spring lecture series is important to understand the law and its challenges from broader, different, and differing vantage points. Acknowledging that international law is a creation of states, it is also important to appreciate the social sciences and humanities that have played a key role in shaping this law. Thus, a broader study becomes quite critical and crucial. Through the series, it is also hoped that one will develop a deeper understanding and appreciation of international law as a creation of states for states and the governance of states, which makes this international law binding. And today, to speak about the entanglement between procedural and substantive international obligations in transboundary watercourses, we have amongst us Professor Dr. Attila Tanzi, who holds the chair for international law at the University of Bologna and is also the president of the Italian branch of the International Law Association. He's also held various distinguished positions in foreign universities and also been the director of studies at the Hague Academy of International Law almost 24 years ago. He has also been a member of the Permanent Court of Arbitration, a conciliator of the Court of Conciliation and Arbitration of the Organization for Security and Cooperation in Europe. He's also been the chairman of the Implementation Committee of the UNECE Water Convention and legal consultant to Italy's Foreign Ministry. On several occasions, he's also been a member of Italy's delegation to the Sixth Committee of the United Nations General Assembly, which is the International Law Commission. He's also held professional activities such as a counsel, arbitrator in interstate and investor-state cases of investment law, the law of the sea, environmental law, jurisdictional immunities, and international organizations. He's also authored a number of books and will now also be contributing to a chapter to the forthcoming book of the Society, which is scheduled to be published next year. Let me stop here and invite Professor Tanzi to share his perspective on the topic, which is gathering further and further traction not only in Europe, South America, but also in the Indian Peninsula. So,
Thank you very much, Ankit, for your kind presentation, and congratulations on your academic endeavor with Jindal University. I am very pleased to have been invited for the second time. And I will speak on a subject which I have been studying and practicing for a number of years, and by doing so, I have detected a rather rough spot that may be worth emphasizing. That is the relationship of an entanglement nature between procedural and substantive international water law. It is well known, I mean, there is no discussion about international water law being based on three basic legal pillars. You have the equitable utilization and the no harm and the cooperation principles. It has also been for quite a while taken that the equitable utilization and the harm prevention principles are of a substantive legal nature, in the sense that they provide for obligations to do or not to do in using transboundary freshwaters. Whereas the obligation of cooperation has a procedural, mainly procedural configuration, in the sense that it addresses the way in which co-reparents apply the two substantive legal principles, namely in a cooperative way. Today, I will show how in contemporary international law, with the increased relevance of environmental concerns and the awareness of the interaction between water quantity and water quality issues more than ever, also the substantive law principles are permeated with procedural obligations, both in relation with the obligation of cooperation, but also with each other, irrespective of a cooperation framework. My speech will come in four parts. First, the largely procedural obligations making up both the equitable utilization and the no harm principles will be addressed in relation to the procedural obligation principle of cooperation. Second, the procedural obligations in hand will be illustrated as part and parcel of the very due diligence standards which are required by the no harm rule and the equitable utilization, independently from a cooperation context, precisely when cooperation is not possible due to the uncooperative attitude by co-reparents. Thirdly, I will address the entanglement between the procedural and substantive water law obligations by reference to the interaction between the equitable utilization and the no harm principles with each other. Finally, I will conclude by pulling the strings of the integrated approach narrative, and by stressing how this integration approach also enhances the normativity of the substantive international water law principles, also in relation to the possibility, and not just a theoretical one, where agreement between co-reparents would aim at departing from the sustainability rationale of international water law. It is always given for granted that cooperation aims for the optimal compliance with the basic principles of international water law, but it can well happen in practice that states may cooperate in a different direction. In my arguments, I will rely on the consolidation or restatement, if you wish, of customary international water law by the 1992 UNECE Convention on the protection and use of transboundary watercourses and international lakes, which has, based on two amendments adopted in 2003, in 2016, it has been open to all members of the United Nations, that is to say, not just members of the UNECE pan-European framework. And the second pillar I will refer to as a constituent element of this restatement, contemporary restatement of international water law. I will rely on the 1997 United Nations Convention on International Watercourses, the travaux préparatoires of both conventions, subsequent state practice, and international case law. Obviously, in the time allotted to me, I will not refer to the authorities underpinning each and all of my arguments, but I may refer you to my writings on the subject. Terminology-wise, I will refer to international distributive justice as the normative setting which flows from international rules and principles which pursue the optimal use and management of transboundary water resources, as well as the allocation amongst co-riparians of environmental, economic, social, and political values and benefits. It is worth recalling how the international water law process has been a precursor to a distributive justice and fairness approach to international law since the 1906 Mexico-United States Agreement on the equitable distribution of the waters of Rio Grande up until the recent United Nations Codification Conventions, which I have just mentioned. Therefore, the concept of distributive justice here is not to be conflated with wealth transfer. It would rather be intended to promote resource sharing between co-riparians in the pursuit of their optimal utilization, optimal in both economic and environmental sustainability terms. My considerations will build upon the firm view of the ICJ President Joan Donoghue, who has long militated in favor of the integrated approach in question, as epitomized in her separate opinion in the Costa Rica versus Nicaragua judgment, where she stressed, and I quote, not to find it useful to draw distinctions between procedural and substantive obligations, unquote. Let me now turn to my first part, the entanglement of procedural obligations with the two substantive principles of international water law in their relation to the principle of cooperation. And let me start from the equitable and reasonable utilization principle in relation to cooperation. This principle has been codified in Article 5 of the United Nations International Watercourses Convention, giving expression in the non-navigational context to the community of interest principle, which was set out by the Permanent Court of International Justice in the River Order case. According to the Permanent Court of International Justice there, and I quote, the community of interest in a navigable river becomes the basis of a common legal right, the essential features of which are the perfect equality of all riparian states in the use of the whole course of the river, and the exclusion of any preferential privilege of any one riparian state in relation to the others, unquote. In Gabčíkovo-Nagymaros, between Slovakia and Hungary, the International Court of Justice endorsed this principle and applied it to the non-navigational context. In line with this principle, Article 5, Paragraph 1 of the United Nations 1997 Convention provides that an equitable and reasonable utilization of an international watercourse requires, and I quote, taking into account the interests of the watercourse states concerned, unquote. This language reflects the famous statement by the 1957 Lake Lanoux Award between France and Spain, in which the tribunal stated, and I quote, according to the rules of good faith, the upstream state is under the obligation to take into consideration the various interests involved, to seek to give them every satisfaction compatible with the pursuit of its own interests, and to show that in this regard, it is genuinely concerned to reconcile the interests of the other riparian state with its own, unquote. In order to give effect to the equitable and reasonable utilization principle, Article 5, Paragraph 2 of the 1997 United Nations Convention on International Watercourses lays down the obligation for co-riparians, and I quote, to participate in the use, development, and protection of an international watercourse, unquote. For today's purposes, it is notable that the Convention specifies that, and I quote, such participation includes both the right to utilize the watercourse and the duty to cooperate in the protection and development thereof, unquote. In its preparatory workings, the International Law Commission also referred to the concept of equitable participation, emphasizing that, and I quote, the core of this concept, equitable participation, is cooperation between watercourse states through participation on an equitable and reasonable basis, unquote. More concretely, it's specified as follows, and I quote, the principle of equitable participation flows from and is bound up with the rule of equitable utilization set out in paragraph 1. It recognizes that, as concluded by technical experts in the field, cooperative action by watercourse states as necessary to produce maximum benefits for each of them while helping to maintain an equitable allocation of uses and affording adequate protection to the watercourse states and the international watercourse itself, end of quotation. Now, it may be noted that it can well occur that under a given treaty, a riparian is afforded a preferential privilege in relation to another or other co-riparians. But that is precisely agreed upon by the treaty having regard to specific waters or watercourses in exchange for other preferential privileges concerning other specific waters or watercourses. Now, be that as it may, the community of interest approach shows the distributive justice rationale of the equitable utilization principle as a normative framework for balancing the equities of co-riparians in a manner which has to be compatible with the principle of sustainability. The determination of the equitable and reasonable character of a particular use depends on the evaluation of a number of factors, which are listed under Article 6 of the United Nations International Watercourses Convention. Some of such factors pertain exclusively to the riparian state or riparian states in the plural potentially affected. Accordingly, such a determination can hardly be unilaterally made by the state of origin, but must given the community of interest rationale interpretation and should rather be made by a joint assessment between all states concerned through some form of cooperation, institutional cooperation or otherwise, or by a third party in a process of dispute settlement. It is notable that the International Law Commission, while commenting on the then would-be Article 5, Paragraph 2, felt the need to state that, and I quote, watercourse states have a right to the cooperation of the other watercourse state with regard to such matters as flood control measures, pollution abatement programs, drought mitigation planning, erosion control, disease vector control, river regulation, training, the safeguarding of hydraulic works and environmental protection as appropriate under the circumstances, end of quotation. I believe that this statement corroborates the interplay between cooperation with its procedural and instrumentals, slant and configuration, and the due diligence substantive obligations of international water law. In so doing, it also enhances the interlinkage between the equitable utilization and harm prevention principles with each other, as well as between these principles and environmental protection. As pointed out by Professor Lammers, the concept of equitable utilization and participation, I quote, means more than the mere duty to cooperate. It relates to two kinds of interferences with water. That is, not only interference caused by human activities, which is characteristic of the principle of equitable utilization, but also interference by nature, end of quotation. And I believe that this statement, which dates back to the 1980s, is particularly relevant this day and age in light of the dramatic increase of climate change and climate change effects. Now, the concept of participation by co-recipients in the use, development, and protection of an international watercourse entails more than procedural activities, such as notification or exchange of data or consultation. A broader range of activities by watercourse states are required, such as flood control measures, erosion control, disease vector control, river regulation, and the safeguarding of hydraulic works or environmental protection at large. Even though such measures do not directly concern the economic exploitation of a watercourse, such should not be lost of the fact that conservation of a watercourse is instrumental to its long-term, also economic utilization, which means its sustainability, indeed in economic and environmental terms alike. Under the UNECE 1992 Water Convention, the equitable and reasonable utilization principle is set out in Article 2 as an integral part of the no harm or harm prevention rule, if you wish. The consistency between the two conventions on this point is corroborated by the UNECE Guide to Implementing the Water Convention, which significantly relies on the guiding factors relevant to equitable and reasonable utilization as they are set out in Article 6 of the New York 1997 Convention. And the participatory element of the equitable utilization principle as set out in the New York Convention is accommodated in the Helsinki 1992 Convention by the fact that the principle of cooperation represents a functional pillar to an extent unknown in the New York Convention through the meeting of the parties, its subsidiary organs, the implementation committee, and the obligation to enter into watercourse agreements, setting up joint bodies to an extent which is not enshrined in the New York Convention, which in its turn dwells more in detail on proceedings such as notification, consultation, and the rest of it, which under the Helsinki Convention is to take place within the institutional framework, which is set up under Article 9 of the Helsinki Convention. As for the relation of the procedural obligation of cooperation to the no harm rule, now that we have seen its relation to the equitable and reasonable utilization principle, well, their entanglement draws from much the same community of interest concept, no less than with regard to the equitable and reasonable utilization principle. Cooperation is key to the performance of the no harm rule as much as it is in relation to the operationalization of the principle of equitable utilization. This is particularly so on account of the fact that the best possible assessment of the appropriate harm prevention measures in any given case will require the involvement of the state or states who may be adversely affected by a particular use, no less than that of the state whose use may cause significant harm. As stated by the arbitral tribunal in the mentioned Lake Lanuk case, I quote, a state wishing to do that which will affect an international watercourse cannot decide whether another state's interests will be affected. The other state is the sole judge of that. Unquote. The best way for the potentially affected state to prove its good faith would be for it to accept, or rather require, cooperation, or at least consultations with the planning state, and obviously to render itself available to, if not triggering, third-party assessment. Indeed, under Article 17 of the New York United Nations International Watercourses Convention, where a putative victim state finds that certain planned measures would be significantly harmful, it has the right to claim to enter into consultations and negotiations. Now, the determination of the threshold of significant adverse effect has to be made on a case-by-case basis, since it depends on the specific circumstances pertaining to each transboundary basin. For the proper assessment of the significance of the potential harm, cooperation among the reparent states, including exchange of data and information and consultations, is key. To this effect, states may also have recourse to the procedural obligations pertaining to cooperation, as they are codified in different forms and in different degrees in the two codification conventions, but preferably through joint bodies of the kind provided for in Article 9 of the UNECE Water Convention, and of which we have many bilateral and multilateral water agreements around the world. Unilateral national conduct may be instrumental in assessing the appropriate significance threshold in any given case and prepare safe legal ground for it in view of future disputes. I am referring to national or subnational setting of emission limits and water quality objectives and criteria. Some transboundary basin agreements lay down such eco-standards, sometimes through soft law instruments, which are helpful in the assessment of the admissible threshold on case-specific terms. In so doing, they facilitate the objective assessment of the scope of the no-harm rule on a case-by-case basis. Such procedural measures and standards, whether they are adopted jointly or individually by co-reparents, represent an integral part of the due diligence nature of the no-harm rule. And as I will stress shortly, the same applies just as well to the due diligence nature of the equitable and reasonable utilization principle. It is therefore likely that a state which is in non-compliance with the just mentioned procedural due diligence obligations would be at variance with both substantive legal principles. The question may be whether the occurrence of harm is a precondition for there to establish the existence of a breach of such substantive principles, especially a breach of the no-harm rule. But not only, as I will illustrate shortly, a use which causes significant harm may be presumed to be in breach also of the equitable and reasonable utilization principle, save in case of evidence to the contrary. To exclude an a priori breach of the substantive rules in question when significant harm has not occurred, despite significant breach of procedural requirements, would seem to set at naught both the procedural and substantive obligations of international water law in question. Clearly, within the context of cooperation or communication between co-reparents, communication of an environmental impact assessment at a transboundary level ranks at the top of the list of procedural obligations, but the environmental impact assessment and notification thereof cannot be seen only as a form of cooperation, namely the elaboration and communication later of an environmental impact assessment in and of itself would be instrumental in the fulfillment of the due diligence obligation of harm prevention, of which any co-riparian is individually the bearer, the recipient individually, irrespective of a cooperation context. Now, it is self-evident that the planning state could hardly substantiate the argument that it has taken all the appropriate measures to prevent causing significant harm if it had not made a prior assessment of the impact that the planned measures would have on the environment and on other co-riparians, with special regard to such conduct having also to be considered equitable and reasonable at the same time. In sum, the rationale of the procedural obligations in a cooperation context, such as mentioned, exchange of the appropriate data and information, notifications, including environmental impact assessment, appears to be that of fostering the participation of co-riparians in the actual realization of the aims of the substantive principles of international water law with regard to harm prevention, elimination, mitigation, and in a word, equitable and reasonable utilization, development, and management of the international watercourse at hand. As such, the core of the procedural and substantive obligations of the United Nations International Watercourses Convention, jointly considered, provides a basic framework for dispute prevention and or settlement, as the case may be. In pulp mills between Argentina and Uruguay, which revolved around 1975 bilateral agreement, a disputed one, which was very much in line with international customary water law, the International Court of Justice stressed that, and I quote, "It is by cooperating that the states concerned can jointly manage the risks of damage to the environment that might be created by the plans initiated by one or other of them, so as to prevent the damage in question through the performance of both the procedural and the substantive obligations laid down by the 1975 statute, the agreement," end of quotation. And the court added that, and I quote, "The two categories of obligations complement one another perfectly, enabling the parties to achieve the object of the statute, which they set themselves in Article 1 of the said statute," end of quotation. However, regrettably, I would say, the court maintained that the procedural and substantive international water law obligations have a normative life of their own, thus ruling that Uruguay's conduct was in breach of procedural obligations, but not of the substantive ones. This approach was strongly objected to by judges Alcasone and Sima in their joint dissenting opinion. And this attitude, the court's attitude, was reiterated by the court in Costa Rica versus Nicaragua, then also criticized by Judge Donoghue in her separate opinion that I just referred to in my opening remarks. I will now come to my second point, namely to how procedural obligations would give effect to the substantive obligations of international water law through individual state conduct, irrespective of a cooperation context. Now, from what I've said so far, it appears that the three normative pillars of international water law ideally represent three essential cogs in a wheel, where cooperation makes the wheel go round. It's the catalyst for the realization, operationalization, for giving effect to the obligation of equitable and reasonable utilization and harm prevention. At the same time, each of the three principles also operate singly. And this is particularly the case of the two substantive principles, since it takes at least two to cooperate. It can well occur that a good-willed riparian state may nonetheless be met with the non-cooperative attitude by one or more co-riparians. This would inevitably render the obligation of cooperation impossible for the goodwill the riparian state to fulfill, but it would not render compliance with the substantive principles impossible for either of the co-riparians concerned individually. Now, given the crucial intersection between the territorial sovereignty principle and the no-harm rules, the due diligence standards, which are the essential components of the no-harm rule, as well as of the equitable utilization principle, are in any case to be complied with by co-riparians individually. And this is corroborated by jurisprudence acknowledging the formation process of the no-harm rule, as well as of the equitable utilization principle. Let me revert once more to the ICJ, again in pulp mills. And I quote, "The principle of prevention as a customary rule has its origin in the due diligence that is required of a state in its territory. It is every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. A state is thus obliged to use all the means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state. This court has established that this obligation is now part of the corpus of international law relating to the environment. The court referred to one particular aspect of the procedural dimensions of the due diligence obligation of harm prevention in the following terms, I quote, "Due diligence and the duty of vigilance and prevention which it implies would not be considered to have been exercised if a party planning works liable to affect the regime of the river or the quality of its waters did not undertake an environmental impact assessment on the potential effects of such works," unquote. Clearly, again, the undertaking of an environmental impact assessment appears as a procedural duty which a riparian state can fulfill irrespective of the cooperative attitude of co-riparians. The point was later reiterated in the Nicaragua versus Costa Rica cases, where the court found that the disputed road building would trigger the obligation to undertake an environmental impact assessment, an obligation which Costa Rica individually was found to have failed to discharge. Further to the finding of the failure by Costa Rica to undertake an environmental impact assessment, the court did not deem necessary to consider Costa Rica's conduct in relation to its duty to notify or consult. It simply assessed the wrongfulness of the omissive conduct in question by noting that, and I quote, "Costa Rica had not complied with its obligation under international law to perform an environmental impact assessment prior to the construction of the road," unquote. That is to say that when suitable cooperation by co-riparians proves to no avail, that does not mean that the riparian states individually are exempted from the procedural and at the same time substantive obligations in question. A degree of dissatisfaction has been voiced also in the legal literature concerning the ambiguity by which the court in Nicaragua versus Costa Rica, due to the lack of express characterization of the breach of the obligation to undertake an environmental impact assessment as a breach of the due diligence no harm rule. Colleagues and judges complained that the court simply characterized as wrongful the breach of the procedural obligation in question as such, without bringing the reasoning to its reasonable conclusion that by infringing upon a procedural obligation so instrumental to the compliance, to the operationalization of the substantive rule by breaching this key procedural obligation embedded in the substantive rule would involve at the same time the breach of the substantive due diligence obligation of harm prevention. Indeed, in Nicaragua versus Costa Rica, just as well as in Palm Mills, the court found that there was no breach of the no harm rule. Why? Because significant harm had not been caused. Now, the due diligence nature of no harm, as opposed to an obligation of results or a so-called absolute obligation. In this context, the occurrence of harm does not amount per se to a breach of law by the state under whose jurisdiction the harm-causing activity was carried out. It's not automatic that if harm occurs and you can prove that you have, in good faith, adopted all appropriate preventive measures, in that case, you have not breached an obligation which is not absolute in nature. You have to prove that national authorities have fallen short of the appropriate due diligence preventive standards for there to argue that a breach of law has occurred, which is attributable to the state. Now, as we have seen, the due diligence standards include multiple procedural measures, introducing a permit system, requiring also environmental impact assessment, adoption of water quality objectives and criteria, the establishment of monitoring programs, and the rest of it. Based on the just mentioned separation between the occurrence of harm and the breach of the obligation of conduct of harm prevention on the one hand, and the procedural nature of many of its due diligence standards on the other, one would assume that the breach of no harm could well be attributed to a state when its due diligence standards, including those of a procedural nature, have not been complied with, irrespective of the occurrence of harm. As already mentioned, a significant degree of non-compliance with procedural obligations should be required for there to be a breach of a substantive water law rule. Such measure of non-compliance might change on a case-by-case basis according to multiple drainage-specific circumstances. Geographic, hydrographic, hydrological, environmental, economic, demographic, social considerations, or features pertaining to an engineering project, but would seem contrary to the interpretive principle of effectiveness of interpretation, so-called effet utile, contrary to the effet utile interpretive principle, to exclude a violation of the substantive rules in question just because significant harm has not occurred, when a breach has actually occurred of significant procedural obligations, which are essential components of the due diligence substantive water law rules. It may be noted that in Palm Mills, the court made at least an assessment of the breach of the procedural obligation to undertake an environmental impact assessment, and it expressly stated that this piece of declaratory judgment was meant as a form of satisfaction, that is, a form of reparation for non-material harm stemming from an international wrongful act. Nonetheless, in their dissenting opinion, joint dissenting opinion, Judge Al-Kasoni and Sima found that, and I quote, "This is not a proper way to pay due regard to the interrelation of procedure and substance," unquote. Adding such statements to Judge Donohue's critical assertions in a separate opinion, Costa Rica versus Nicaragua, which I just quoted, together with the prevailingly critical stand in the legal literature, one cannot help noticing a growing authoritative critical mass against ignoring the entanglement of the procedural obligations with the substantive ones under international water law, if not in environmental law at large, for the purposes of assessing state responsibility in an adjudicative context concerning the management and use of transboundary resources. In light of this growing critical mass, it appears that in the mentioned case law, the court has missed a golden opportunity to authoritatively explain the close interrelationship between the two sets of rules in question and to apply them accordingly. And that is particularly true with regard to the relevance of procedural obligations as an integral part of the due diligence obligations making up the no harm rule and the equitable utilization principle. The court could have addressed the question as to whether and when non-compliance with procedural obligations can of itself amount to breach of due diligence substantive rules of international law. Reverting to the substantive principle of no harm as a basic yardstick, the question whether it can be breached in the absence of transboundary damage is a matter for a case-specific evaluation. The answer would depend, as I mentioned already, on a kind of multiple procedural obligations that have been breached. The golden formula epitomizing the due diligence mode of operation of substantive international rules and principles is captured by the obligation to take all appropriate measures or to make best efforts. Authoritative guidance for a case-specific assessment of the appropriateness of the required preventive measures in order to comply with the no harm rule as well as to the equitable and reasonable utilization principle can be found in Article 3 of the 1992 UNECE Water Convention on prevention, control, and reduction. I will not mention all of that, but I may refer to emission of pollutants to be prevented, controlled at source through the application of law and no waste technology, limits for waste water discharges to be included in permits based on the best available technology for discharges of hazardous substances, biological treatment or equivalent processes to be applied also at the municipal wastewater, where necessary, according to the specific country capacity, which may be financial, technological, legal, and administrative capacity in a step-by-step approach. Appropriate measures, such as the application of the best available technology in order to reduce nutrient inputs from industrial and municipal sources, environmental impact assessment indeed, sustainable water resources management, contingency planning, the risk of accidental pollution to be minimized by local authorities' plans upon request by central government. Where necessary, total or partial prohibition of the production or use of polluting substances and the rest of it. The normative, now I will come to my third, last point before the conclusion, the entanglement between the procedural and substantive obligations in relation to the interaction and integration between no harm and equitable utilization. There's no denying that the concept of equitable utilization as a development of the principle of equitable apportionment of waters has grown out of the need for the economic regulation of conflicting claims over water quantity issues for agriculture and later hydroelectricity purposes, prior to the formation of the no harm rule, which addresses primarily, but not exclusively, transboundary pollution issues. There is sufficient authority showing that the equitable utilization principle has survived the formation of the no harm rule, especially under the two multilateral water codification conventions that I am referring to constantly as evidentiary of international customary law. After the emergence of the no harm rule, the equitable and reasonable utilization principle has developed so as to adjust also to and to encompass within its scope of application water quality concerns. An integrated approach to water quantity and quality concerns in international water law is reflected precisely in the mutual integration between the equitable and reasonable utilization principle and the no harm rule as they have been codified in the two codification conventions in question, which is also evidentiary of general opinion juries of states and the legal literature and case law. On the other hand, the UNECE Convention of 1992, under Article 2, the equitable and reasonable utilization principle is characterized as a fundamental due diligence standard within the framework of the harm prevention rule. But this is to be complemented by the United Nations Convention of 1997, which spells out the equitable utilization principle in terms according to which optimal and sustainable utilization goals must be pursued consistent with the adequate protection of the watercourse. Thus, the New York Convention also incorporating environmental and water quality concerns within the concept of equitable and reasonable utilization. And in its turn, the no harm rule has been drafted in the same New York United Nations Convention so as to complement the rationale of the equitable utilization principle in the same environmental terms. And this is evidenced by the travaux préparatoires of the no harm provision, in which the International Law Commission stressed, and I quote, that it was setting forth a process aimed at avoiding significant harm as far as possible while reaching an equitable result in each concrete case, unquote. Let me jump to my concluding remarks. The multiple procedural obligations apply to co-riparians individually as constituent elements of the equitable and no harm due diligence principle. This is probably one of the main messages that comes out from my analysis. Whereas traditionally, since concerns around the world in order to apply international water law as a system of rules aimed at conflict prevention and conflict management or settlement, the main focus has been put on cooperation. But I've tried to decouple the general principle of cooperation to safeguard the continuation of the legal force and operation of the substantive obligations that characterize international water law, even in a situation in which cooperation is not possible.
Thank you. Thank you so much, sir. Is that all?
Yeah, I can stop there then.
Well, you can continue. Sorry, I thought that was all.
No, I can stop there. I have miscalculated my timing. I thought I would be speaking for 50 minutes, but I think I've passed the 50 minutes.
57. That's all right. Let me just pose a few questions which bother me as I sort of think about this. Water disputes seem like boundary disputes, but a specialized or a different species within the classification of boundary disputes. But what sort of differentiates them is is, as you classify them as those three spokes within the cycle which work in unison. But what would happen if these spokes turn on one another? Which is to suggest that optimum utility and sustainable use or substantial use. Now, this is language of the clause as well. But what would happen? How do you theoretically and normatively it makes sense, but how do you actually undertake this? And perhaps that's the heart of all disputes which you've discussed as well. um, I'll just pose two short questions in addition to this. Second being the aspect of territorial integrity of the downstream and up the upstream state to determine the utility of the water resource to the other state. And the third question sort of relates to this in the sense of the utility and also the functionality of the UNECE to set up commissions, to set up, let's say, specialized commissions, and perhaps from these commissions also create a charter like what Senegal has, because all these states are going to otherwise, at least the riparian states, are going to get involved in disputes repeatedly. So if there is a charter which sets out these provisions with clarity and categorically, such disputes perhaps could be avoided. I'll stop there and come back with another question on human rights and the utility of human rights courts in the Americas, and the Africa continent, and of course Europe as well.
Thank you very much, Ankit. Three very good questions. I'll try to give you the short answer, shorter than my presentation, as usual. I will start from the last one. I got three questions. The last one being, how to make the most and what's the sense of the great emphasis that the 1992 UNECE Convention places on institutional cooperation as a great means for dispute prevention and management. And you're absolutely right. That is the key feature of the convention. Aside from corroborating the substantive and procedural obligations, even though less than the New York Convention, I alluded to the fact that the Helsinki Convention, 1992, is less elaborated on the procedural cooperation obligations, notifications, consultations, deadlines, the terms for all this. Why? Because it is compulsory under Article 9, paragraph 2, that the states parties to the UNECE Convention have to enter into transboundary water agreements, setting up joint bodies. And they have to carry out that kind of cooperation which involves notification, exchange of data and information and the rest of it within the very institutional body whose establishment is compulsory under the convention. And next to that, as much as the whole institutional system, which involves also the permanent body of the meeting of the parties, which meets every 3 years and has a bureau which carries out its working subsidiary bodies throughout the triennium. They have also established an implementation committee, which I'm still chairing, and that introduces a different perspective to international water law. Now, Article 22 safeguards the possibility of international adjudication before the International Court of Justice or whatever other forum that the parties would be willing to choose, and arbitration. So it is, the whole machinery is without prejudice to arbitration and adjudication. But next to that, whereas adjudication provides for the actual assessment of a breach of the law, attributing forms of responsibility, attributing the wrongfulness of a given conduct, the machinery revolving around the implementation committee, which would be working hand in hand with the meeting of the parties, sets aside, suspends the concept of state responsibility in favor of situations of non-compliance. I mean, one could say, but this is playing with words. At the end of the day, non-compliance amount to breach of the law, except that once you go before international arbitration and adjudication, even though you have increasing case law and precisely the recent arbitration and ICJ case law on water disputes corroborates the application, a degree of distributive justice. You have seen it in all these cases, pulp mills, Nicaragua, Costa Rica, and I would even say Kishinganga to an extent, which invites the parties to refer to similar or the same arbitration system, where the adjudicators provide for elements in order to reach enhance agreement between the parties. Within the UNECE mechanisms, you have a situation in which account may be given to reasons for breaching the law, which is simply termed as non-compliance, also due to lack of capacity, to difficulty, and you have a system of assistance in the sense that the implementation committee mechanism, rather than coming down with an assessment of non-compliance, prior to that and possibly avoiding that, may indicate which difficulties are being met by the states concerned and how the institutional mechanism of the convention may help in accommodating such difficulties, which may be technical, maybe even financial, administrative, and the rest of it. And we have just come out of a recent virtues case study example in which one state, and I can mention it because that is in the public domain, and that is Montenegro, came to the implementation committee lamenting possibilities, having difficulties with hydropower plants underway, being planned, and some already ongoing in Albania. And we asked, under the rules which established founding decision, we addressed Albania, and Albania accepted to cooperate. And the end result of the process has been a pretty, so far, successful one, in which the parties are cooperating with the support and the legal and technical scientific support from the committee, but the parties are doing most part of the job. Let me jump to the first question. You're right, absolutely right, and many transboundary water related disputes are entangled with boundary disputes. I know of a number of, particularly number of cases in Africa there, because it was traditional since the old days that rivers would provide themselves boundaries. And I think if any water law dispute is a case-specific one, because it depends on all factors, social, geological, geographical, hydrological. The fact that the water dispute is complemented by a dispute over boundaries, that is something that you cannot deal with in absolute general terms. I can just say, as a matter of fact, you're absolutely right. And in any case-specific circumstance, you would, as an adjudicator or as a diplomat trying to help the parties to settle the dispute, you would wonder whether it is to follow a piecemeal approach and say, let's first decide on the boundary delimitation, and then let's see how we can handle the transboundary dispute delimitation, or whether anticipating the best way you could optimize the utilization of the transboundary river or basin system, including groundwaters, it will be best to adjust the boundaries, trying to cajole the understanding of the parties that that specific delimitation would be perfectly instrumental in the optimal utilization of the shared resources. And I think that this community of interest concept, the holistic approach, in a way, rather than seeing one territorial dispute settlement or boundary dispute element as a complication, maybe the combination of the two disputes may end up with finding the best solution to both the boundary and the shared natural resources dispute.
So in some sense, are you explaining what a watershed commission is? Is that really the definition for what would be classified as a watershed commission? Or is that something slightly different?
Well, I was rather putting myself in terms of those who would be simply either negotiating the solution, normally impossible, or a third party involvement. I think these are kinds of disputes where, as much as we talk about cooperation, when boundary delimitations are involved, concessions, diplomatic, negotiated concessions are little viable, as I believe, also from national policy, from national policy standpoint. So in that way, I think that the shared natural resources complications may help the third party to submit win-win solutions to the disputing parties, in which they can see more of give and take packages, in which concessions and benefits can be negotiated for the ultimate general benefit for all parties involved. So in a way, adding a transboundary resources dispute to a boundary dispute may add to the options for the best mutually agreeable and mutually convenient delimitation of the boundaries, so that after the boundaries have been determined, then the best economic, environmental use can be made, precisely made on how many transboundary resource disputes we have because of an awkward former colonial administrative delimitation, mistakes made in the past, which makes optimal utilization difficult precisely because both disputing states cling on to their territorial sovereignty principle. Either you call it territorial integrity or territorial sovereignty as such, but they cling on to the awkward delimitation, and this complicates the functional utilization of the shared resources. Having both kinds of disputes, components of one dispute, may perhaps help exploring the best way out on both counts, and then you can shoot two pigeons with one stone.
But staying with the game theory, would you say that it's only considered viable when they have to manage a disaster, which is to say that compliance or complicity or cooperation is sought in order to mitigate a larger disaster? I mean, you can use the pandemic as an example for this with vaccine sharing, vaccine diplomacy as well. So what I'm essentially saying is, and even for that, countries which don't have acts on pandemics use disaster management acts like India did. So perhaps win-win is only looked at when they have to mitigate something. Let me just also pose my final question. There seems to be this large trend to focus on arbitration, mediation, and conciliation in such disputes. ICJ has only been announced or asked for in 3 instances. So perhaps there remains a reference to utilize not a court but an arbitration mechanism to find a solution which might be optimal. Is that a is that a reading which is in some sense appropriate, and also claims, and this is quite open, claims made under the purview or garb of human rights to the various inter-American, European, and African courts on human rights, and so sort of a claim made on human rights and utility to water and water resources as a right to life, and then looked at to sort of distribute these resources.
Right, thank you very much. Just one gloss on your observation. Disaster, and you have a lot of disasters around water courses. Flooding is pestering Europe, all continents. And what I noticed is it depends. Sometimes states are wary of, out of a disaster to open their territory to international help. So you were talking about game theory. Game theory assumes rationality of the actors involved. Sometimes disasters may prompt irrational and strongly territorial sovereignty inspired reaction to close the territories. We had it also with nuclear disasters. About the wide range of dispute settlement mechanisms between the ICJ and arbitration, conciliation. Well, I see the pros and the cons, and then you put human rights into the whole thing. I think that amongst the factors for there to assess the equitable and reasonable utilization of a given river, you have social factors. None of the factors involved should enjoy priority, the New York Convention says, but under Article 10, reference is made to the fact that vital human needs have priority over any other factors in order to assess the equitable and reasonable utilization character of a given use. So if I read the considerations behind any given case in which social concerns of the populations, depending on the disputed watercourse, I would very much regard the International Court of Justice having perhaps a little bit of legal, cultural, and institutional advantage, being the principal United Nations organ, where you apply Articles 1 and 55, you have an inherent mandate and the legal culture for the 15 or maybe 17 judges or 16, according to the number of judges that you would have. And they have a very good record of considering the application of human rights involved in whatever disputes, particularly now in this particular case where the body of applicable law provides for priority being given to vital human needs. Otherwise, given the technical nature, the often very, very technical and specialized nature of water-related disputes, arbitration seems to be the form of dispute, the means of dispute settlement, perhaps more suitable to these kinds of disputes. For all the obvious reasons that are well known about the advantages of arbitration, particularly a 5-member or 7-member arbitration panel, where you would have control by the parties to some extent, control in terms of culture, expertise, seems to be very good. Humanitarian considerations have also been considered in the past by arbitration tribunals. So I suppose that answers your question about what is my instinct about these points.
Indeed. Let me just take this opportunity to thank you, Professor Tanzi. As always, it was a riveting experience hearing from you, and obviously learning from you is always such a delight. And I think just one parting thought I have, given I've just returned from Heidelberg and Max Planck Institute, focusing on foreign relations law. I think national states have also started to adopt laws which transform their practice vis-a-vis these transwater boundary courses. Can I, if I can you just share your thought on that? Because this is an afterthought as perhaps a footnote. But if you could share your thoughts on that, we can do this next week as well. But if you can share your thoughts on that.
Let's do it next week.
Sure. All right.
We have
Thank
taken
you.
so much time out of our fellows and mates. So thank you so much.
Wonderful.
Let's speak on Monday next week.
Thank you. Thank you so much, sir. I look forward to meeting you and continuing our growing professional relationship. Thank you so much for your time, sir.
Thank you, and good luck with Jindal University and your plans. Thank you. Bye
Thank
for
you.
now.